is an appeal in the matter of Amrani and Harker and others and Muca and Amrani.
Mr. Cohen.
My lords, my lady, I appear on behalf of the appellant in the matter of Harker, and my learned friend Mr. Morris appears on behalf of the respondent. And in the other appeal before this court, that of Muca, Mr. Morris appears on behalf of the appellant and Mr. Decker on behalf of the respondent. The parties have agreed a timetable, so to speak, for today, which provides that I'll be making submissions to midday, followed by Mr. Morris, and Mr. Decker, and then we will turn full circle with Mr. Morris by myself, and the final word being the appellants in our respective appeals. Finally, so far as housekeeping is concerned, I hope the court has before it a core bundle in my appeal of some 315 pages and a short supplemental bundle of some 146 pages. There is a joint authorities bundle in the amount of 549 pages. And finally, in the Muca appeal, I understand there's a core bundle of some 245 pages.
I can't claim to have checked all the page numbers, but that sounds right.
Great.
It is right.
With respect to my submissions, they will proceed as follows. First, I'm going to address the court so far as the facts and judgment are concerned. I'll be making brief submissions thereafter on the principles relating to the interpretation of statute so far as my case is concerned. I will then move on to Trecarrell, and finally we'll be making my submissions in relatively short order, given that they are set out in my skeleton argument. With respect to the facts, my client, the trustees, granted the respondents an assured shorthold tenancy of flat D, top floor flat 65 Chippenham Road, for the first time on the 9th of November 2007. That was for a term of 12 months. So far as the terms of that tenancy is concerned, we have the tenancy for the years from 2008 up to 2019, but there's no dispute that the terms of the tenancy dated November 2007 were the same as those that followed. And with respect to those terms, if I could invite your lordships, your ladyship, to core bundle tab 12, page 149. That's tab 12, page 149.
Yes.
This is the agreement dated 9th of November 2008, and as I say, it was the same as that which preceded it and all those that succeeded it. At the top it says it's agreement AST under Part 1 of the Housing Act of 1988, and then if one goes over the page, you see the final page of this document, which is page 7, and it's signed at 150. The terms that occupy pages 1 to 6 are at page 161. So these are the terms of 161, and if I can draw the court's attention, if I may, to paragraphs 2 and 3 on 161.
Which paragraph? Sorry, which paragraphs?
2 and 3 on 161.
The two begin this agreement.
This agreement,
Yeah.
exactly.
It doesn't matter, but in the electronic bundle, you have to add 3. So this is page 164.
I'm very grateful, my lord. I'll try and factor in the mental arithmetic as I make my submissions. As the court will see, paragraph 2 reflects the parties' mutual agreement that the document is intended to create an assured short-hold tenancy, and importantly in my submission at paragraph 3, they expressly agree that the provisions for the recovery of possession of the premises contained in section 21 apply. From November 2007, there were 12 sequential annual ASTs, culminating in the final one, dated 9th November 2019, which is at page 173, which will be 176 PDF. The manner in which these tenancies coexist, given that following the expiry of each one of these tenancies, absent the grant of the succeeding tenancy, there'll be a statutory periodic tenancy, is on the grant of each one there is an implied surrender of the one before. the consequence of which is that self-evidently there is only one tenancy in existence at any given point. So every November, on the grant of the succeeding tenancy, there's an implied surrender of the tenancy that pre-existed it. On the determination of the fixed term of the final tenancy, that of 9th November 2019, thereafter the respondents occupied the property pursuant to the statutory periodic tenancy under section 5. I'll come to very briefly. So far as the history of gas safety records are concerned, the best evidence comes from the decision of the Deputy District Judge at trial, to which I'm going to invite to return, which is behind tab 9. It starts at page 94 on the paper pages 97 PDF. The trial itself, just for your ladyship to note, was heard on the 30th of February 2015, judgment handed down a week later on the 21st of February. With respect to the written judgment of the Deputy District Judge, at paragraph 16, which is on page 105, PDF 108, is a summary of the evidence of Appellant Harker, who's one of the trustees of the property in question. It just explains that one of the trustees, Mr. Jude Powell, began managing the property and thereafter, as a consequence of his conduct, he was replaced by other trustees. Evidence that of Mrs. Harker is summarised in paragraph 22, that's 106/109. In the third sentence of 22, Ms. Harker stated that she could not say whether a gas safety certificate had been served in 2007. She was aware that British Gas had been dealing with the gas services since 2004 and that landlords were only required to hold copies of gas certificates for 2 years. She had found certificates for 2008 and 2009 and had asked British Gas whether they could supply copies of gas safety certificates for other years, but they had told her they could not go back earlier than 2012. If I might just break from the judgment at this point to say that for all of the years of occupation, the only years for which there are no gas safety records are for 2007 and 2011. And I'll come on to the judge's finding of fact in respect of those. In brief, for 2011, the judge was satisfied that there was a certificate given. In 2007, he concluded that there was an inspection, there was a certificate produced, but on the evidence, he was not satisfied that that certificate had been given pre the respondent's occupation of the property on the 9th of November 2007. Reverting back to paragraph 22, the third sentence up from the bottom recites the fact, or records the facts that it was put to her, Ms. Harker, that she had not given a gas safety certificate in 2007, and her response was that she was unable to comment, and then goes on to recite British Gas's policy. First sentence of paragraph 23 reflects the rolling agreement that existed with British Gas, and then if one turns to paragraph 50, we have the Deputy District Judge's findings of fact. 50 is on 115/118. At the bottom of page 115/118, the judge makes the point that where there are conflicts of evidence, he prefers those of Ms. Harker to those of the respondents. Top of 116/119, the judge provides that he's satisfied by Ms. Harker's evidence on the balance of probabilities there was a standing arrangement in place with British Gas. British Gas carried out an inspection every year, even in those years for which no gas certificate has been located. And then at the bottom of that paragraph, the judge sets out the probable explanation, which is that through passage of time, some of the documents have gone astray. And he bore in mind that there is only a requirement under the gas safety legislation, which we'll come to retain documents for 2 years. Over the page at paragraph 53, which is on 7/120, the first 10 lines of paragraph 53, the Deputy District Judge identifies the question before him, which was whether the claimants were precluded from serving section 21 notice in the absence of evidence that the claimants provided the defence of gas safety certificate before they went into occupation. He concluded by reference to a case called Hathaway and Minister that there was no such obligation At the bottom of 117.120, in 2 sentences up from the bottom, the judge writes, however, in the present case, while there is no evidence that gas safety was provided, that does not mean the certificate has not been obtained. The reasons given above in relation to Harker's evidence about the standing arrangement of gas and the certificate had probably been obtained. And then at paragraph 54, 118121, 54, the first sentence recites the Deputy District Judge's conclusion that only the last record had to be served, and more importantly, in the second sentence, he provides that the reasons I've given, I'm satisfied an inspection by British Gas will carried out each year, and to feature of the arrangements between the claimants and British Gas, the gas certificate each year will be sent by British Gas to both the landlords and the tenants. The net effect of these conclusions are that the judge was satisfied on the evidence that there were inspections, that certificates were produced, and for every year from 2008 that the certificate had, or the certificate / record, they're one and the same thing, had been given to the respondents. Moreover, he was satisfied in 2007 that a certificate would have been sent to the property, but did not come to a conclusion on the evidence that the 2010 certificate had been given to the respondents before they occupied the property.
Just to be clear, if it had been sent to the property, that needn't have come to the attention of the respondents.
Indeed, and if it had been addressed to the tenants, then they would have received it before they occupied, on the basis they would have occupied on the date of the grant. And there is a factual distinction, so I understand, between this appeal and the Muca appeal. The Muca appeal, there was no inspection, there was no certificate. Here we have an inspection of a certificate, but evidentially couldn't come to the conclusion that it was given to the occupation. There is a standard practice with respect to ASTs as well, that all the gas safety certificates are reserved before the Section 21 notice anyway, given the effective carolers that you need to have given them all prior to the Section 21 notice, notwithstanding what the legislation requires otherwise, and that took place in this case as well. So on the 25th of October 2023, all of these gas certificates, again, save 2007-2011, which can be repeated, but it's only 2007 that matters, given Carol in respect of 36(6)(a), which I'll come to. All of those were reserved on the 25th of October 2023. Section 21 notice is dated 31st of October 2023, and that's behind tab 12, page 183/1. 6. That's 183/186, and that is dated 31st of October. One sees at 184/187, and it was served on the 2nd of November, expiring on the 5th of January 2024. The claim was issued on the 19th of February 2024. The claim itself starts at 127/130. And just for your Lordship's note, at 139/152 is a table setting out the dates of issue of the various gas safety records and the dates of service. It does not include this table the 2008 and 2009, because they were discovered after the date of issue when my clients were going through their paperwork. So there was 2008, 2009, and then you've got every single year thereafter. And so far as the facts of this appeal are concerned, given the date of the last fixed term on the 9th of November 2019, if the second interpretation, which I submit to this court, is preferred, then it's the gas safety record dated 24th of October 2019, which would be the one which had to be served pre-occupancy for the purposes of what I described as interpretation 2, and so far as interpretation 3 is concerned, it is simply the last 2, which is the one that was found in one of the county court decisions that I'll come to. It'll simply be the top 2, so to speak, so that dated October 2023 and October 2022. The defence was served on the 6th of March 2024, that is behind tab 13, and for these purposes one needs only go to paragraph 10.6 on 264/267. 264/267 and it's paragraph 10.7 and it's the final 5 lines that issue point which is now come before this court. That's paragraph 10.7 on 264/267. However, the court did not decide the issue of what happens where there was no first gas safety record at the start of the tenancy. The defence will submit as a proposition of law if the first gas safety record is not obtained, and landlord may not ever rely on Section 21 notice, and or this is not redeemed by giving subsequent gas safety records after the tenancy has commenced. The trial, as I have made mention of, took place on the 30th of February, judgment handed down on the 21st of February. There was an order for possession made, which one sees behind tab 10 of 123/126. That's the order for possession. And one sees from paragraph 2 that it adjourns the other issues, being those relating to costs. And then over the page behind tab 11 of 125/128, you see the order so far as costs are concerned, which is in the usual format, which is that the respondents paid the appellant's costs that are subject to protection in section 26 of LASPO given to respondents. The tenants appealed. The ground of appeal is behind tab 6 at 75/78. And importantly, so far as the ground of appeal is concerned, one sees 75/78 at tab 6 in paragraphs, first 2 lines of paragraph 3.2 and paragraph 3.3, that the judge made no finding that a gas safety record was given to the defendants before they moved into the property, or that a pre-occupation gas safety record was provided for section. That's the first sentence of 3.3. The appeal was heard on the 4th of December 2025, and His Honour Judge Hellman handed down judgment orally on the 3rd of February 2026. The judgment is behind tab 5. This is page 45, PDF 28. The material paragraphs of this judgment start at paragraph 41, which is 54/57. Paragraph 41 on page 54. One recites counsel then acting for my clients who in his written submission decided not to pursue what I describe as interpretation 2, but then raised it orally at paragraph 42. And at paragraph 42, the judge sets out as follows. During oral argument, Mr. Stokes canvassed the possibility that paragraph 36(6)(b) required a copy of the last record to be given to every new tenant before that tenant occupies the premises in their capacity as a new tenant, even if immediately before the start of the tenancy they were already occupying the premises under a previous tenancy. So that's interpretation 2. And the judge rejected that construction, the reason being there would be no need for the landlord to provide a tenant who is already in occupation of the premises for the record under paragraph 36(6)(b), as the tenant would be entitled to a copy of that record under paragraph 36(6)(a). So the reason given for rejecting interpretation 2 is that on that basis, the same notice could fulfil the 2 subparagraphs of 36(6). Over the page to 54, this is 56/59. 52 onwards concerns the decision of Her Honour Judge Melissa Clark in the case of Castle Sidhu. 54 is an extract from that judgment, which I'll come to in due course. If I can just invite the court to read paragraph 57 and 57/60. And then over the page to 65, 62, Mr. Stokes, then acting for my clients. Following Castle and Sidhu, it says, invites the court to construe relevant period, that should be relevant record. It says relevant record, in other words, in the 2015 regulations we'll come on to, as including the rider, the relevant record actually means those records that the landlord was required to retain under paragraph 3C of the 1998 regulations, which is the last 2 years. So that is how interpretation 3 comes into being as a consequence of this decision, and that was put by my predecessor to the judge, and the judge rejected that. At paragraph 68 and 69, if I could just invite the court to read 68, 69 right. So,
Yes.
read from an over page 70, he concludes that the district judge got it wrong. And then at 71, I must therefore consider the question fresh. And in that paragraph, he rejects interpretation 3. The order against which this appeal is brought have 4, which is 43/47. My lords, my lady, that concludes the section on facts, so to speak. The bare consequences of the judge's decision below, so far as my clients are concerned, is notwithstanding that the parties agreed through each one of these written tenancy agreements that they were to be not just assured shortfall tenancies, which is a term of art, but more importantly that the provisions for the recovering possession in section 21 should apply. The effect of this judgment is that the tenancies granted after the 1st of October 2015 are in substance assured tenancies because the appellants could not evidence service of a record from before the 9th of November 2007, even though there is no dispute that the gas check in question was carried out and the record produced. And even though at no time prior to the 1st of October 2015 was the giving a record a precondition to rely on section 21 as a basis of grant of possession. And what that means, if one stands back and looks at these facts, it means that my client is being penalised and that it's prohibited from relying on an agreed term in a contract by reference to its failure to evidence something done 12 years previously at a time when that penalty for that failure did not exist.
But why is that odd or surprising? Because legislation changes from time to time.
Indeed, but as
and why you place a lot of emphasis on agreement, but if legislation has a certain effect, then what does it matter that the parties have agreed something else?
My lord is about the proposition. I don't dissent from that, but as I come on to, particularly focusing on the various presumptions in venue, which I'll come on to, there is a heavy presumption in my submission when it comes to penalising a party for events that have taken place in the past. And when we're looking at two statutory regimes which inelegantly interact with each other and are not, in my submission, brilliantly drafted, as we'll see from the variety of cases and the expansive arguments before you, those presumptions, particularly that against doubtful penalisation, should loom large in circumstances where a party's contractual rights are affected by reference to events in the past, in circumstances where the legislation did not, at the point at which those events take place, purport to affect those contractual rights. But so far as the broad proposition, if that's what the statute says, then that's what it means, then I don't dissent from that. But because we're understanding, or embarking on the exercise of what it means in circumstances where they're not going to be drafted, it's at that particular point that I think that this issue is large.
Can I also just understand that it's, as I understand it, it's the fact that assured short-hold tenancies were actually granted after the regulations came into force that would have this result. If the last grant of a contractual tenancy was before the 2015 regulations came into force, and what continued afterwards was a statutory tenancy under Section 5, we would not be here, is that? Have I understood that?
You have, my lady. I'll come on to deal with deregulation,
Yes.
but it's paragraph 43 that provides that the provisions made thereunder, which the 2015 prescribed regulations, bind only on tenancies, ASTs granted after the 1st of October 2015. So if you had a pre-October 2015 AST of whatever term, but thereafter the right of the occupants to remain in possession is a Section 5 statutory continuation tenancy, we are simply not in this country. In other words, Section 21A, which prohibits the ability of a landlord to serve a Section 21 notice unless a precondition is satisfied, does not apply.
Yes, because the regulations do not
exactly
um,
exactly my
bite
point.
in
They
that
do not bite on.
situation.
Exactly. So far as the exercise of interpreting these regulations is concerned, I'm going to deal with them only very briefly because they'll be all familiar to this court. In the authorities bundle, if I can ask the court to turn on tab 17. Tab 17, that is page 286, PDF, it has that 3-page increment, then it'll be 289. This is the Supreme Court in the Packer case, and there is a nice submission, a very neat and digestible summary insofar as these principles can be digested at paragraph 40, that's 300, I think would be the same.
No,
No,
actually,
that pages work.
it is. Yeah, the pages work. It is. So which page are we on?
It saves my mental arithmetic. So we're on page 300 and it's paragraph 40 which sets out what it is that this court is going to be doing, and it's particularly paragraph 41. When we're interpreting legislation, is to identify its purpose, and at this point I do emphasise that the 2015 prescribed regulations and the gas safety regulations have very different purposes. And because interpretation 1 focuses on the 2015 prescribed regulations, I will have a separate set of submissions on the purposes for those, and then of course the gas regulations, which stem from 1998 but actually first existed in 1994, have a different set of purposes, and interpretation 2 focuses on interpretation of that wording. It is those purposes that one needs to have in mind. Paragraph 43 is a summary of absurdity as the concept sits within the interpretation of statutes, and as one can see from paragraph 43, and particularly the final 4 lines on 301 and the top 4 lines on 302, the concept of absurdity is far more elastic than those or that bare words suggest in and of itself. So it's any result which is impossible, unworkable, impracticable, inconvenient, anomalous, illogical, futile, pointless, artificial, productive, and disproportionate account of mischief. And again, I'm just going to move very quickly, if I may, to Benyon, which will put a bit of those core principles. Benyon is behind tab 20, which is page 450. And at 451, I can just invite, of course, have reference to the 3 lines, 4 paragraphs up from the bottom, which simply says the presumption against absurdity is one manifestation of the principle, and the interpreter is to have regard to the consequences of differing constructions when interpreting a provision. And then 452, the 3 lines at the top, the presumption against absurdity is simply a guide to legislative intention and is therefore most likely to be successfully relied on with the alleged absurdity. It's not a necessary consequence of an otherwise cogent statutory scheme. It cannot be justified on other grounds. 465. We have another manifestation of this presumption. It's 465, and it's the top 5 lines. Presumption against absurdity means that courts will generally avoid adopting a construction that creates an anomaly or otherwise produces an irrational logical result. The effective legal system seeks to avoid unjustified differences and inconsistencies in the way it deals with similar matters. As Lord Devon said, no system of law can be workable if it isn't got logic rooted. 489. Is the principle against doubtful penalisation. In the middle of 489, 3 lines, which are as follows: the presumption against doubtful penalisation is not limited to the imposition of criminal liability. It applies whenever a particular construction of an act can be described as inflicting death of any kind, whether criminal or civil. And then over the page of 490, under the words in bold, chancing one's arm, Benyon provides that given that the presumption against doubtful penalisation is based on ideas of basic fairness and the need to warn people of the potential adverse consequences of their actions. Over the page at 227.6, this is 492, we have a presumption against interference with economic interests. And 7 lines down under the Blackstone, it says the general principle against interference with property includes favouring alienability and inalienability, even in cases where some degree of interference with the person's proprietary rights is clearly intended. Legislation will be construed as interfering with those rights no more than the statutory language and purpose require. And then, so far as the presumption against
Sorry, just before you move on from that last point, I mean, how much force does that have in a context where Parliament is acting in what might be called a social sphere, and is in the field of landlord and tenant law, going over the last century, if not longer, there have been various recalibrations of where the balance of rights between landlords and tenants should fall to give effect to differing social policy over time. And it's not a matter for the courts to say whether those were good policies or bad policies. We just give effect to the law. I get the point. Antic Carrington, one is very familiar with, but interference with property rights or economic interests is sort of what landlord and tenant reform does.
Yes, but the presumption is that one doesn't go further than the wording of the statute matters. And there's a commentable assumption in Cavendish, which is summarised in Hipsley Point, which I'm going to come to, which makes that point good. In other words, one doesn't go further than the wording mandates that you have to go. The point at which one goes beyond it is when one offends against this presumption. But again, I certainly don't dissent with the proposition that landlord and tenant is one of the most heavily regulated areas of law, that this presumption only bites insofar as there's a degree of elasticity or uncertainty as to the scope of the interference with proprietary rights. Hipsley Point, which includes that extract from Lord Sumption in the case of Cavendish, also in the bundle, but I won't go to that unless it's helpful, is at tab 19. And this is case dealing with Building Safety Act from this recently, and it's at page 407. Is my Lord Justice Newey's summary of the presumption against retrospectivity. That's 407, and particularly paragraph 53 of 407. And the D is an excerpt from Amrani, which writes the general rule of the common laws that a statute changing the law ought not, unless the intention appears to be with reasonable certainty, to be understood as applying to facts or events that have already occurred, such way as to confer or impose or otherwise affect rights or liabilities which the law had defined by reference to these past events. The presumption against interference with property rights is also summarised at paragraph 60. This is 410. And at paragraph 64, is I think the answer to my Lord's question, with reference, as I say, to the commentable assumption in S. Francis, which was Landlord and Tenant 1954 Act. That extract is from paragraph 16 of Francis, which is at page 229. I don't propose to go to it, but it's there. My submission is now going to focus on the two regimes in play. Those, of course, being the regulation of landlord and tenant law and gas safety regulations in the context of property. So far as the landlord and tenant law principles which are engaged, the Housing Act 1988 governed the grant of tenancies from the 15th of January 1989. Before the 15th of January 1989, and we were in Rent Act 1977 territory. As originally propagated, the Housing Act of 1988 provided only for assured tenancies. And I'll come on to what actually, in a practical sense, the difference between assured tenancy and an AST is. Assured short-hold tenancies existed, but they became the default form of tenancy from the 27th of February 1997. So, Housing Act 1988, the default tenancy was an assured tenancy. You could have ASTs, but from the 27th of February 1997, at the point at which the Housing Act 1966 came into the AST regime became a default regime and took place that had hitherto been applied like assured tenancies. The Housing Act is behind tab 3 of the Authorities Bundle. And behind tab 3 is a number of relevant sections, and I'm going to move through them quickly just to set the scene, so to speak. Section 5.1, this is page 10 of the Authorities Bundle. 5.1 says an assured tenancy cannot be brought to an end by a landlord except by obtaining an order of the court under section 7 or 21. Now what's important here is that an AST is a species of assured tenancy. They are not distinct. What the AST does is provide an additional basis in section 21 to terminate an assured tenancy. So one can terminate an assured tenancy in an AST on the same basis, which those in Schedule 2, which are the fault-based grounds, there's been arrears and the like. But what an AST has that an AST doesn't is the ability to terminate on a no-fault ground, which is what section 21 provides. Section 5.2 is over the page, on page 11, and the combined effect of 5.2 and 3 is to provide for the statutory periodic tenancy that arises at the end of a fixed term. That's 5.2 and 3 on page 11. Section 7 is on page 15. Recall section 5 provides that an order of court can only be made under section 7 or section 21. Section 7 is the section that introduces Schedule 2, 7.1, the first two lines of 7.2. And then at 7.3 and 7.4, we have the mandatory grounds, which are part 1 of Schedule 2, and then we have the reasonable grounds, which are part 2 of Schedule 2, and these apply to assured tenancies and ASTs. Page 25 is section 19A, which was introduced by the Housing Act. Section 96 of the Housing Act, 1996, introduces section 19A, and it provides an assured tenancy which is entered into or not after the day on which section 96 of the Housing Act comes into force, which, again, if you'll note, the 27th of February 1987, is going to be an AST unless it falls within any paragraph in Schedule 2A. Section 21 is at page 28. Section 21, as I say, applies only to assured tenancies, and it sits within Chapter 2 of Part 1, which is dedicated to ASTs. Section 21.1 is the notice given during fixed term, and again, it's important in section 21.1 is it provides that the court shall make an order for possession if notice has been given. That's section 21.1. And then over the page is section 21.4, which provides notice during a periodic tenancy, whether it's statutory or otherwise, and 4A and B provide again that if notice is given in the form mandated in this subparagraphs, then an order shall be made. And then 4ZA beneath it, so far as a dwelling house in England is concerned, gets rid of the troublesome last day of the tenancy and brings the termination of statutory periodic into line with the notice given during fixed term, which is that you need to have 2 months of it in fixed term. It can take effect after the termination of fixed term. Section 21A is on page 34. Section 21A, as I will go on to show, was introduced by section 36 and 41 of the Deregulation Act. Section 21A applies only to short-hold tenancies, and it provides that a notice under subsection 1 or 4 of section 21 may not be given in relation to an assured short-hold tenancy in a dwelling house in England at a time when the landlord is in breach of the prescribed requirement. At a time when the landlord is in breach of the prescribed requirement. 21A2 provides that the requirements which may be prescribed to requirements imposed on landlords by any enactment, and it will be that we are interested in here is the health and safety of occupiers of dwelling houses. Separately, albeit that I think this is just for your note only, it also introduced section 21B, which is on page 38. 21B also provides the statutory regulation require information about the rights and responsibilities of the land. And what you will see in various cases is that there is reference to an EPC certificate, a gas safety record, and a how to rent guide. The how to rent guide is 21B1. The EPC certificate is 21A2C. And what we're concerned with here is health and safety, which is gas safety record, which is 21A2B. On page 46 is Schedule 2. Schedule 2, as I said, contains the grounds by which assured tenancies, which within that umbrella includes ASTs, can be terminated pursuant to section 7. And in part 1, we have the mandatory grounds, and then in part 2 are the grounds whereby the judge is also satisfied that it's reasonable to order possession. And again, just by context, page 54 you see ground 8, and 55 you see 10 and 11, and it's very common in possession actions to be relying on 8 to 10 and 11 being the grounds when it comes to arrears of rent, and those are the mandatory ones, and then you've got later on reasonableness ones. And then
Just digressing briefly, have you still in the background got your claim relying on these grounds?
it is in my client specific.
Yes.
I have to take instructions. My lord, the answer is yes.
Yes.
And my lord, that brings into light the way in which these possession actions are commonly started. Section 21 notice, Section 8 notice, and then one relies on 21, and then if for some reason one can't, one has the backup grounds.
Yes.
So yes, there are arrears of rent, I understand that.
Yeah.
Schedule 2A is at 66. Schedule 2A, you will recall, was introduced under the Housing Act and is the circumstances in which, after February 1997, landlords and tenants can agree that the tenancy question should be an assured tenancy, not an assured short-hold tenancy.
Sorry, I wasn't keeping up. Which page are we on?
Sorry, forgive me, 66. Schedule 2A.
Yes.
And for example, you can still grant an assured tenancy even under this regime, but there are provisions as to notices that one sets out in paragraph 1 and paragraph 2. And notices have got to be served at a certain time and date, which, sorry, it's paragraph 1, paragraph 2, and then 2 is the date of service. And then if one goes over the page at 67, there are other forms of tenancies which are automatically assured tenancies, so forwards motor tenancies, secure tenancies, tenancies replacing non-short holds and assured agricultural holds. The Deregulation Act is behind tab 7. The material provision is at page 99. And it's 38 regulation, section 38 on 99 introduces section 21A. And then section 41 at page 101 refers to my Lady Justice Falk's question. Section 21(1) provides that a provision of sections 33 to 40 applies only to an AST or dwelling house needing granted on or after the day on which the provision comes into force. It's 1st of October 2020.
Sorry, where are you reading from?
41(1) on page 101. The subordinate legislation referred to in section 21A are the prescribed requirements regulations which are behind tab 8 at page 108. Regulation 1.1, they come into force on the 1st of October 2015. And then at 1.3, 109, a fine in relation to an AST of dwelling house needment granted on or after the first month. It's regulation 2, which sets out the requirements prescribed for the purposes of section 21A. Regulation 2.1a deals with EPC certificates, and then it's 2.1b. The requirements prescribed are the requirements contained in paragraph 6, or as the case may be, paragraph 7, of Regulation 36 of the Gas Safety Installation and Use Regulations 1998, requirement to provide a tenant with a gas safety certificate. And then Regulation 2.2, which was the regulation that particularly focused this court in Carroll, provides that for the purpose of section 21A of the Act, the requirement prescribed in paragraph 1b is limited to the requirement on a landlord to give a copy of the relevant record to the tenant, and the 28-day period for compliance with that requirement does not apply. I'll come on to the gas safety regulations to explain how that applies. The explanatory notes on page 116, if I could just ask the court to read the second paragraph of 116. Again, we see it talks about a gas safety certificate, and the last sentence, no fault eviction procedure for ASTs, not available on the landlords at a time when either of the requirements, that's the EPC and the gas safety, have not been complied with. Reverting then to the gas safety rules themselves, the first mention of regulating gas appliances in residential dwellings appears in Regulation 35 of the 1994 regulations. They're behind tab 4. This is page 72. So in 1994 we have the first point at which gas safety and tenancies are engaged. And it's Regulation 35.2, which imposes a duty on the person who owns a gas appliance to ensure that the appliance is maintained in safe condition. 35.3a is the requirement to check at intervals of longer than 12 months. 3b is to keep a record, and again these survive into the modern incarnation of it. And then 4 is that the record should be made available upon request to any tenant. The amendment regulations came into force on the 1st of April 1996. This is over in tab 5, page 73. This is the Health and Safety, Gas Safety, Installation and Use Amendment Regulations 1996. And if one looks at 73, the words in bold just above paragraph 2 refers to the Gas Safety Installation and Use Regulations in 1994. But if one turns to page 77, we have a new section 35A, which is introduced. And looking at 77, the defined terms survive into the 1998 regulations. The obligations are extended to licensees. That's because the new definition of lease and tenant, particularly tenant on 78, it introduces the saving provision for landlords in paragraph 7, and those core obligations to inspect every 12 months, keep records, and remains. It is the 1990.
Sorry, just hang on a minute.
Sorry, forgive me. If one looks at the amendment regulations, it's 2 in the middle of page 78 that continue this duty to maintain in safe condition the relevant gas fitting. 3 is the repetition of the obligation to inspect or check intervals of not more than 12 months. And then we've got keeping of the record. 4 is a new provision which provides that, 4 is a provision that provides anyone who does work needs to be appropriately certified. And then it's 5 is again making these records available on request.
At the risk of stating the obvious, is this right that at this time, this is just freestanding health and safety legislation? This is not furnishing grounds on which there may be a notice to secure possession of rented premises or anything. It's nothing to do with that.
Yes, my lord, and that remained the position until the 1st of October 2015.
Yeah.
Until that stage, you just had a separate set of duties and obligations,
Yeah.
none of which vested a cause of action in a tenant or anything like that. It was simply a set of requirements on a landlord, part of the gas safety regulations, which cover all kinds of.
And presumably potentially giving rise to criminal consequences.
Indeed.
At this stage, there's no reference to keeping for 2 years.
No. And both the
You're going to
giving
come
of
to
2
that.
years and the giving of records is introduced in the 1998 regulations, which were at page 82 behind tab 6. And I'm going to go through this, if I may, in detail. 36(1) defines landlord, and it's landlord with reference to both the lease and a license, and it's the person entitled to the reversion immediately expectant on it. And then lease has a very specific definition. It's a lease for a term of less than 7 years, or a tenancy at a periodic term, or a statutory tenancy, arising out of either of those two. And again, statutory tenancy is then defined. Over the page 3, relevant premises is defined as a premises which is occupied exclusively or not for residential purposes under the lease or license. The definition of statutory tenancy is restricted only to a statutory tenancy within the meaning of the Rent Act 1976. It does not include the statutory tenancy arising out of the Housing Act 1988. I have tried to do some digging as to why that should be, and the best I could come up with, I'm afraid, is conjecture on my part. But given that this was introduced in the 1996 regulations, which is still reasonably close to the point at which Rent Act tenancies were the common form which exists up to 1989, and that the succession provisions for Rent Act tenancies are much more generous, so to speak, than they are under the Housing Act, it may well be that is why this is identified to not the Housing Act. There was obviously a deliberate choice here, because at the point at which in 1996 these came out, the Housing Act regime was the predominant regime. But because you could have statutory succession in much more generous terms, you can have a new tenant, so to speak, albeit under the same tenancy, when someone who's got a Rent Act tenancy dies and it goes to their spouse or anything like that. So that is my explanation of it. I have to accept that's conjecture on my part. The definition of tenant is indelibly tied to the person who is occupying for the time being entitled to the term of the lease. So tenant itself is referable to the term of the lease that entitles them to be there. Regulation 36(3)(a). 3A reflects what existed as far back as 1994, which is the obligation to check every 12 months. 3B is a new obligation, which is in respect of a lease, and again the definition of lease includes a license, commencing after the coming into force of these regulations, ensure that each appliance of fluid to which the duty extends has been checked for safety within a period of 12 months before the lease commences, or has been so checked within 12 months after the appliance of fluid has been installed, whichever is the latest. And what's important about regulation 3B is the duty to check is tied to the point of commencement of the lease. Regulation 36(3)(c) is the 2-year requirement for keeping records. And for these purposes, I'm going to ask the court to ignore the fact that there are square brackets, because there were consequent amendments to this, but the 2-year obligation has remained at all times from 1996.
And just to be clear about that, if one looks at the annotation for F3, that refers to the 2018 amendment regulations, but the 2-year requirement does go back to an earlier stage.
Yes, what the 2018 did was introduce the words until there had been 2 further checks of the appliance that flew under this paragraph, or in respect of an appliance flew removed from the premises for a period of 2 years. So as originally, and I'll make this
Yes.
video for short development, but as originally promulgated, it simply said 2 years. And then there was this additional catch provision that was introduced in 2018, which is to say until there have been 2 further checks.
Yes, I see.
But it was originally just a fixed term of 2 years rather than 2 checks, and then you can dispense with that previous record. Regulation 36(3)(c)(1) to 9 sets out what needs to be in the gas safety record. The data checking addressed the premises of the landlord, the defect identified, the remedial action taken. And again, what's important about here is this is about the provision of information. Again, there's no cause of action. This is simply saying to the tenant, by the way, here's a gas safety record, don't use that plug, for example. 4 on 84 again reflects the predecessor regulations, which is about the certification of the person who's doing work. And then 5 again reflects the predecessor provisions, which is the record is available upon request to any person in lawful occupation. And then 6, and just as regulation 36(3)(a) and B is under substantial revolutions, 6 in itself is an entirely new provision imposed in 1998. And it's clear that 6A and B link back to the checks in 3A and B. So the checks are 3A and B. C is the product of those checks, and then it's the product under 6A and B that then needs to be given to the tenant. And we can see that because 6A says a copy of the record made pursuant to the requirements of paragraph 3C above is given to each existing tenant premises to which the record relates within 28 days of the date of the check. And you'll recall from the 2015 regulations that regulation 2.2 dispenses with the obligation to give within 28 days. And then 6B says a copy of the last record made in respect of each appliance and flue is given to any new tenant premises to which the record relates before the tenant occupies those premises. That obviously, in my submission, relates back to the obligation to check in regulation 3B, which is to check within 12 months of the date of the commencement of the lease and or a later point, depending on where the 12 months of obligation under 3A actually arises. And what's important about 36B is there is a saving provision. It says save that in respect of a tenant whose right to occupy the premises for a period not exceeding 28 days, a copy of the record may instead be prominently displayed within those premises. Now, I emphasise this point in respect of interpretation 2. Interpretation 2 seeks to identify the new tenant, the obligation to give the record to the new tenancy which gives rise to the right to occupy. And support from that arises from the saving provision, because it says save that in respect of a tenant whose right to occupy those premises. So what it does is it takes out from the class of those to which otherwise it would apply those whose right to occupy the premises is for not exceeding 28 days. And again, the fact that it specifies the right to occupy those premises by sufficient lends further support to interpretation 2, which doesn't regard occupies as some freestanding entity occupying for the first time as put by the respondent or the judge, but links occupation to the lease that identifies the tenant as the new tenant. And again, further support from that comes from the definition of tenant itself, tenant means the person entitled to the term of the lease. One could arguably have new tenant in the abstract, and you'd say you're not a new tenant because you were a previous tenant. But I don't think that works, because if one interpolates into new tenant definition of tenant, what it means is the person coming to the term of the lease that hasn't done so before, because tenant is referable to the term of the lease in question. So you are a new tenant if, with respect to the term of the lease that gives you the right to occupy, you have not come to that term before, rather than in the abstract you're not a new tenant because you were a tenant previously. Which at one level is quite an attractive submission for me to be putting, but because the definition of tenant relates to the term, I think it must mean that in respect of the term in question, you are new for that term.
Yes, but one of your difficulties with that is the actual contrast with 3B, which talks about before the lease commences. You've got a contrast between that wording and going into occupation in 6.
I agree, but I think comfort can be taken from the saving provision 3 lines down, which talks about the right to occupy those premises. And it's because it refers to right to occupy those premises in the context of a new tenant, where tenant is defined by the person entitled to the term of the lease in circumstances where the relevant premises, which is the premises which is referred to in Regulation 36(6)(b), itself is residential purposes under that lease. We have an overarching structure which links the occupation to the identity of the tenant, to the fact it's residential premises and its right to occupy, rather than simply having occupy as a freestanding concept.
So if I understand correctly, you're saying new tenant, well, tenant means tenant under this particular lease, therefore they are new when that lease commences.
And what it is that interpretation 2 seeks to do is, after the word occupy, interpose the words pursuant to the lease that makes the tenant the new tenant. Whereas what it is that the respondent and judge concluded is that after the word occupy, you simply have the words for the first time. And those are the two contrasting positions on interpretation 2 as against judgment under appeal. It's whether occupies means occupies for the first time, or occupies pursuant to the lease that renders the new tenant tenant.
Well, yes, I'm not sure about this point, about whether words are being read in or not. You're suggesting that under either interpretation, words are being read in.
That is what I'm submitting, because the word itself occupies in the context of this regime, I say, is ambiguous. And so what I put forward is 2 alternative sets of words to be interposed. No doubt the point will be taken against me that actually what it is the judge or respondent is doing is not imposing words at all. But in circumstances where you have occupies in line 2 and then in line 3 right to occupy, which presupposes a contractual right to be there, in my submission that ambiguity is there, which means that whichever way one look at it, one is interposing words for the sake of either clarity or to remove that ambiguity. And again, it's the contrast between occupied and right to occupy in those lines 2 and 3, which I think does, in my submission, bring that point clear. Before I move on to Chicago, I will make one subsequent point, which is that the marrying up of the 2015 regulations and the 1998 regulations is not an exact exercise. There is no perfect alignment. You can have ASTs to which the 1998 regulations do not apply. The 1998 regulations apply only to leases of under 7 years. ASTs have to be under 21 years. So you can have ASTs to which the 1998 regulations apply. Equally, you can have residential tenancies to which the 1998 regulations apply that the Housing Act doesn't. So, for example, the Housing Act has a low rent threshold. In Schedule 1, if you have a tenancy, for example, in London, where the annual rent is less than £1,000, you fall out with the Housing Act, but you would still fall within the 1998 regulations, because all the 1998 regulations requires for relevant premises is that they're occupied for residential purposes in consideration of money or money's worth. So if you had a £500 rent, for example, for a term of 5 years, you'd be in the 1998 regulations, which would not be under the Housing Act. Equally, the 1998 regulations would apply to an occupier of a hotel. You do so under a licence, because the 1998 regulations apply to licences, but you would not fall within the Housing Act regime because that wasn't. I don't seek to make any particular point. It's just an illustration of the fact that we have two independent regimes and we're trying to find a path that brings a path that actually reflects the legislative intent.
On that theme, before we go to Tricaro, can we just go back to the 2015 regulations briefly, please? So I'm looking at page 109, 108, 109, the authorities boundary. And regulation 1.3. These regulations apply in relation to an assured short-term tenancy granted on or after 1 October 2015. Now, one point that occurred to me, which isn't the same as your interpretation too, but is possibly you might describe as a variant of it, is, well, what was Parliament or the regulation makers intending to do when they introduced that provision? You have an assured short-hold tenancy that commences on or after 1 October 2015. Contrast that with this case, where if the tenants are right, Section 21 is effectively excluded because of something that happened in relation to an assured short-hold tenancy that was not within the 2015 regulations. It started in 2007 or whenever it was. So my thought was whether, in interpreting what the 2015 regulations were intending to do, which is limit the introduction, the application, if you like, of the 1998 regime to short-hold tenancies commencing after October 2015, whether that possibly informs the way that, when you turn to the 98 regulations, 36(6), paragraph 6, should be interpreted. Your point about new tenants and so on, might it mean, this isn't your interpretation too, but might it mean essentially the first assured short-hold tenancy after October 2015?
I mean, the answer, you won't be surprised to hear, is yes, my lady. It is a variant of interpretation too, because again,
it's not the same.
It's not the same. So interpretation 2 is siloed to looking at the 1998 regulations. So in fact, what it really is a bit of a merging of 1 and 2, because 1 focuses on the 2015, it's kind of 1.5. But if we were looking at a 1.5, which looks at regulation 1.3, and through the lens of 1.3 looks at the term new tenant in regulation 36(6)(b, we do get to an outcome which enables one to look at new tenant divorced from the definition of tenant in the 1998 regulations, which ties it to the term then in existence. And we could see it as a term of art in and of itself, in which case you'd only be a new tenant in respect of an ASD arising after the 1st of October 2015. So it is obviously, respectfully, inevitably, I'm going to say this if I could, but what it is an amalgamation of 1 and 2 seeking to define new tenant through the lens of regulation 1.3.
Because it seems to me, if I may say at this stage, that some of the points Mr. Morris makes in relation to both your interpretations 1 and 2 have real force, and that's part of what was prompting me to think, well, what are we really, what should Parliament be, or the regulation maker be regarded as actually intending should be the result in this case? Should the position actually be affected, which is the consequence of the tenant's case, by tenancies that well predated 2015 and before?
Yes, my lady, and there is support for that, which one gets from the case of Harker. In Hathaway, this is a tab 15263. This court made the point that in the Deregulation Act 2015, Regulation 43.3, it provides that after a period of 3 years, the regulations apply to every single AST, irrespective of when they come into being. And this court in Hathaway made the point that actually what 41.3 of the Deregulation Act did was give a power to prescribe regulations that had that effect. But actually, when it came to the 2015 regulations, they don't have that effect because they only bite on those that post-date 1st of April 2015. So there was obviously a legislative decision not to cast the net to all those that are in existence after the 1st of October 2018, and rather to simply focus on those that are granted after the 1st of October 2015. And that interpretation that you make mention of sits between interpretations 1 and 2, in that it focuses the legislative intent on what it is clearly designed for, which is new STs after the 1st of October 2015. And it's new grants after the 1st of October 2015, which in my submission it is primarily focused on. And one can get there by this interpretation 1.5, but really that is the outcome that the landlords in both of these cases is putting to this court, which is that the focus of this is on new ASTs after the 1st of October 2015, but quite how one gets there, it is the exercise that
So suppose that's right. Would it follow that? Suppose that the relevant breach has occurred of a prescribed requirement has occurred not in 2007, but in 2014. On your submission, what would follow?
Well, in those circumstances, they simply don't apply, in the sense that 21A bites only on ASTs granted after the 1st of October. And if you had, just as if you had at any other point up to the 1st of October a failure to comply with any of the 1998 regulations, it made no difference as far as housing law is concerned.
Yeah.
If you had an AST that was dated 2014, 2012, whatever it might be, and there were no checks carried out at all, then the law remains in respect of that AST as it was at all times up to 2015.
So the landlord wins.
The landlord would win in those circumstances.
Yeah. What I'm interested in is whether that is necessarily consistent with the social policy which must have lain behind Parliament's decision to enact what it did, and the regulations under the primary legislation in 2015. And this comes back to the point we were debating earlier this morning, that in this field of social activity, Parliament does from time to time recalibrate where the balance of rights between landlords and tenants should fall. It doesn't necessarily follow that it's only going to be prospective in the sense of only applying to tenancies which are created or granted after the legislation comes into force, because the whole point may be that there is a social mischief which has been identified, which Parliament wants to do something about. Now, I understand the rhetorical force of the points you're making in relation to something that happened in 2007, and where it's all very difficult many years after the event and people weren't expected to keep the records. But what you're saying is that your submission would actually be the same even if the breach had occurred in respect of 2014.
Yes, my lord. If we go to Hathaway, tab 15263, this was an EPC certificate that wasn't given in relation to a tenancy that was granted in 2009. Well, that's not quite right. The statutory tenancy arose in 2009. And the Section 21 notice, I'm just reading from the head note.
Yeah.
Section 21 notice was given after 2015, and this court said none of these new provisions apply simply because the tenancy predates the 1st of October 2015. And I think it's quite important when we look at the social policy, and I'll come to Caroline and know how to expand on what that social policy is so far as this concerned. The words used, I think, by Lord Justice Patrick, were spurs and science. They're obviously not an end in and of themselves, as this court in Hathaway provided if you have got a tenancy that predates the 1st of October 2015, it simply doesn't apply. And in those circumstances, you had a statutory periodic tenancy, the EPC certificate was not given in this circle because it predates that point. Section 21 does not give you the tenant the defence of the Section 21 procedure.
Just getting off to tangent road, the Renters' Rights Act sweeps away Section 21 entirely,
It is.
and that applies to existing tenancies.
I'm going to have to look at my notes because I know he gave a talk that
I see, yes.
resounded amongst landlord and tenant lawyers. Perhaps he can answer that question. They can't pretend to know the Renters' Rights Act.
After lunch.
The answer will come whether it's from.
So it might be a more complicated answer. I mean, if it were the case, then that would illustrate that Parliament has the power to take away Section 21 entirely. And this, so to speak, would be taking away Section 21 from a subset of existing tenancies.
When one's looking at any particular statute, as this court knows only too well, we are looking at it through that threefold presumption
Yes.
against, as I say, retrospective self-determination and infringement of proprietary rights. But certainly, so far as this is concerned, it was a line in the sand with reference to ASTs created after that date, irrespective of those existing before.
And just talking around it for a moment, the canny landlord in 2015 appreciating that there could be this problem because they lost the certificate from many years before or whatever, either A, could just not grant any further AST, then they'd be all right, or they could serve a Section 21 notice and evict the tenant promptly before the change of the law took effect. Yes, I see.
I think it's fair to say that this particular set of provisions was part of the grander suite of the Deregulation Act that was all about strengthening tenant rights. So, for example, in the Deregulation Act, there are provisions about retaliatory evictions and disrepairs, and it was all part of the suite strengthening tenants' rights. But you're right, a landlord could have done that. I can't say from experience.
It wouldn't have been a very attractive solution, but it would have been a solution.
It would be a solution.
Yes.
It's also worth bearing in mind that if you've got a statutory continuation tenancy, your ability to increase the rent is subject to the various rent tests that exist in housing. So from a landlord's perspective, it's much more in your interest to agree a new fixed term, so to speak, than simply have a statutory continuation tenancy where your ability to actually increase the rent ends up going to a rent assessment panel in the first tribunal.
Yes.
So one would want to grant a new entity, so to speak, rather than simply sit on the rights that then exist unless the rent itself is elevated. Moving then, if I may, to Appellant, which is behind tab 14. Trecarroll itself is factually distinct, I think, from both of these appeals. In Trecarroll, it was a pre-occupancy gas safety record that was given late.
But also, importantly, all of the events occur after 2015. We do not have any of these points around the introduction.
We don't have any of what I might describe as these legacy arguments. That's really what it is. So in Trecarroll, you have that factual distinction, but also there is a certificate. The certificate was given late, and the point before the Court of Appeal is where you've got Regulation 36(6)(b) saying you've got to give it prior to them occupying. Can you actually give it prior to the Section 21 notice, and to that extent entirely ignore those words as they sit within the 1998 regulations for the purposes of landlord and tenant law? And we see that at E and F in the head note on 243. The landlord failed to give the tenant a copy of the latest gas safety record prior to her taking up occupation. Took the flat 7 months later. It gave her a copy of the gas safety record, which she should have given her before she took occupation. Paragraph 6 on 249. The first 5 lines of 6 set out the intention of Parliament when introducing Regulation 36. The first 6 lines of paragraph, in fact, the entirety of paragraph 7, sets out the provisions of 21A and the consequence of them. Paragraph 8 has the facts of that case. In paragraph 8 it provides that the tenancy was granted in February 2017. The gas safety record was produced on the 31st of January 2017. So you have a gas safety record on the 31st of January 2017. Tenancy commences in February. But the gas safety record was only given to the tenant on the 9th of November 2017. That's an F. There was then a separate question about the subsequent check, which was the 12 monthly check pursuant to Regulation 36(3)A. And at the bottom of 249, you can see it says on the second line at the bottom, the claimant has produced a gas safety record relating to the inspection on 2nd of February 2018. So this is after the tenancy commences in February 2017. You then have 12 months to do a further check, and then at the top of 250 we can say that those factual dispute by the date of the Section 21 notice, which was on the 1st of May 2018. And again, I'll come to just tease out those facts in relation to the later gas safety record. The landlord's argument is at H on 250. And then at the top of 251. So H, the first argument, which the landlord succeeded on, was that you didn't have to give pre-occupancy certificate pre-occupancy. You could actually give it as long as it's prior to the Section 21 notice. And again, we can see the degree to which this court was prepared to perhaps take a slightly more purposive, proactive view to the 1998 regulations, because obviously they state clearly in their face that it's got to be given prior to occupation, but this court, by reference to the 2015 prescribed regulations, was content to put that, not content, found a basis to put that requirement for the service to one side. And at the top of 251 is a separate argument, the landlord one, which is that actually the 2015 regulations meant that you excluded paragraph 36(6)(b) in its entirety. So not as interpretation wants to do, which is to give Regulation 36(6)(b) its purpose and foundation for during the first term, so to speak, of tenancy, but that it did not apply full stop, and that's clear from the words in its entirety. And the basis for that argument being made is at A and B, and what's being said is because Regulation 2.2 as the saving provision in relation to 28 days, it was obviously intended that the pre-commencement checks, the pre-commencement giving certificate was obviously therefore not required, notwithstanding that B is specifically mentioned. Moving then through the authority at page 50, paragraph 15, we're at 252. Paragraph 18, Lord Justice Patton deals with the proposition that Regulation 36(6)(b) is excluded in its entirety. We see that 3 lines down in the first sentence of paragraph 18. And the reason for that is set out in 19. There are 2 reasons why the 2015 regulations didn't mean you totally ignore 36(6)(b). One is self-evident, which is a curious mechanism for actually having that effect, and you name 6(b) in Regulation 1, or Regulation, 2, so to speak. And we can see again at the bottom of paragraph 19, Lord Justice Patton making the point that he did not accept that 6(b) is excluded in its entirety. So 18 and 19 deal with the second argument put forward by the landlord, which is actually the 2015 regulations means you don't need to do Regulation 36(6)(b). The italicized paragraph 2 sets the discussion about the time limits in paragraph 6(b). And paragraph 20 again makes the point that the sole question for the court was whether the claimant's failure to provide the tenant with or to display a copy of the most recent gas safety record prior to her taking up occupation of the flat was fatal to its ability to serve Section 21 notice. And in paragraph 21, the first concern, Lord Justice Patten, was a disparity in treatment of consequences arising from non-compliance with A and B. See that just above H, talks about non-compliance with paragraph 6b as a prescribed requirement imposes a far greater sanction on the landlord than is the case under paragraph 6a. So under 6a you have this express point, you don't need to give it within the 28 days mandated, which one sees in the 2015 regulations. So the first point that concerned that was the disparity in treatment. The next point, which one can see at the bottom of 253 over the page, is the effect would be that there would be an assured tenancy, which was not what the landlord granted. So the first concern was disparity in treatment between the two limbs. The next was the consequence, if this case was right, which is that the parties entered into an assured tenancy, not an AST, we see that in 254. Paragraph 23 makes the point that there is no justification for the disparity in treatment on the basis that it would enable a tenant to know whether it should take the tenancy, because the obligation to give the gas safety record arises after the tenancy is entered into but before occupation is taken up. So that's not a justification for the disparity treatment, that's 23. But paragraph 24, the final 6 lines, makes the point that the sanction for non-compliance with the 1998 regulations is that they're punishable as a criminal offence under section 33 of the Health and Safety at Work Act regulations 1974, that's a D. Whereas the imposition of section 21A of the bar to the service section 21 notice is therefore only collateral to these sanctions and best to spur to compliance.
Is that obviously that's what the court has said, and I appreciate the majority decision binds this court. But I'm just wondering aloud whether that's the only policy one can necessarily divide, because Parliament sometimes gives effect to other social policies, such as that it wants to mark its disapproval of something, or it tries to reflect what reasonable members of society might think is a just outcome. Or why should someone be able to rely on legislation despite their having breached some other important legislation?
I think the answer to that lies in the fact that the effect of section 21A is that it's intended in this court's view in Tracao to be suspensory, so it refers to at a time when. So what it's doing is prohibiting you to rely on section 21 notice at a time when you don't comply. And one of the things that I'm concerned Lady Justice Kings will go on to is the fact that every single other of the prescriptions mandated both in the Deregulation Act and in the Housing Act 2014 are ones that one can remedy.
Yeah. So
if you don't protect the tenancy, you can give it back, for example. So I think the reason why this slightly muted interpretation of Parliament is delighted on by the court in Tracao is the fact that for every other misdemeanour, so to speak, in inverted commas, one can remedy it. And it is clearly suspensory, it is suspending the rights rather than removing it, which would be a slightly more penal sanction.
Are there circumstances in which you can't remedy a failure to give an annual notice, provide an annual certificate?
What Lord Justice Patten concludes in paragraph, I'm going to come to it, some of the respondents' notice in paragraph 31, is that even if you fail to do it annually, that is not, again in the vernacular, it's not a problem. If you do it late, that's fine.
So supposing you had a tenancy for 5 years and you should have done it every year during the 5 years, it's good enough to do it in year 4.
That is what one gets from this decision.
And if you've done it in year 3 and lost the certificate and can't get a copy,
You simply do it again and provide, sure that you've given the most recent copy within the 12-month period before serving the Section 21 notice. I'll come on to deal with the response notice point, because my lord, you're quite right, but what it is that Lord Justice Patten decides is even if you don't do it within the 12 months, that's fine, just do it. And that feeds into this court's view that it was a remedial spur to compliance, again, very much not the bright line in the sand with penal consequences, which is, I think, the effect of both respondents' case and the judge's decision, which is...
And you would say it's not that there are no penal consequences, they are still there, they're in the health and safety regime.
And up until... And it's important that the health and safety regime itself is a series of obligations on landlords. None of these legislative regimes are intended to, in a sense, purposely give rights to tenants. What it's doing is providing sanctions and penalises landlords, so to speak, so it's not giving them rights. But it's the effect of the 2015 regulations on a contract between landlord and tenant that gave this court Carroll the concern that it did and why it concluded as it did, which is notwithstanding that Regulation 36B says on its terms, give it prior to occupation.
But the consequence of Trecarroll, if you put Trecarroll together with the tenant's position, the only non-remedial situation is failure to give one of these certificates before the tenant goes into occupation. Whereas, as my Lord Justice Newey said, you could basically default on the 12-month requirement all through what might be quite a lengthy tenancy and just fix it at the end.
And that's one of the absurdities that I've heard before this court. Because as a consequence of Trecarroll, and if we're looking at the whole suite of regulations that the Deregulation Act brought in, including, for example, those tenancy deposits, the EPC certificate and the like, the only one that is irredeemable is if you don't give a pre-occupancy record. And that means that on the tenant's case, if you have an AST that started after 2015, you gave a pre-occupancy gas safety record, you did not do annual checks for the whole term of it, providing you did a check before the Section 21 notice and gave the record, then there is no consequence for the landlord. Whereas, and that in my submission sits and jars rather with the purpose of what the regulations, 1998 regulations, is intended to do, which is to give tenant knowledge of defects at the date of the notice. That's the purpose of it. I'll come to that in my interpretation of submissions. Really what the tenant's concerned with under the 1998 regulations is at any point in time is there a gas safety appliance which is unsafe. And so the consequence of the tenant's construction would mean that if a landlord had given a historic record however many years previously and had ignored the obligations to do annual checks for 5 years but then did so before the Section 21 notice, that's sufficient. And of course that doesn't sit comfortably with the purpose of the 1998 regulations, which is to give you records from time to time. Historic records of no value to the tenant. Back at Trecarroll from 27. Paragraph 29 makes the point that Section 21 is seen by Parliament as temporary in nature and capable of being cured by eventual compliance. The first sentence of 29. And then it's the first two sentences of paragraph 30, which in my submission is the most important. Although the point is not straightforward, I am not therefore persuaded that for the purposes of Section 21A, the obligation to provide the gas safety record to a new tenant prior to the tenancy of occupation cannot be complied with by late delivery of the gas safety record. Late delivery of the document does provide the tenant the information he needs. If it breaches the consequence from which the cherry contends, then it must apply in every case of late delivery, even if the delay is only minimal. That seems to be an unlikely result for Parliament to have intended, particularly in light of the express rejection of the 28-day deadline under paragraph 6A. Now, in that case, gas safety record was given in November when it should have been given before February. But of course, it still had, and one can't lose sight of the fact that check was in January. So in November, that record was still the relevant contingent record because the 12-month obligation had yet to kick in. So it obviously did have value to the tenant when the tenant received it in November, because there would have been no other check that would have taken place during the currency of the tenancy. As I say, check was in January, tenancy of February, given in November. So you can see why Lord Justice Patton makes the point that it's still relevant to the tenant for this case, but of course in these cases under appeal it's of no relevance to the tenant now whatsoever.
And Mr. Cohen, you're not wasting any time at all.
I'm
But at the
conscious
same
that
time,
I'm
we're obviously
wasting
slipping
time.
behind the schedule.
Yes, I'm conscious of that, and I will happily forgo my reply insofar as I need to, but I think these are important points which
Yes.
I'd like to wish out if I may. The respondent's notice is dealt with from paragraph 32, and if one looks at the 2 lines of 32, the arguments put on 2 bases. First, the next gas safety inspection due after the first January took place more than 12 months after the previous inspection. The claimant originally contended that it took place on the 3rd of April 2018, but now says that this was an error and there was an inspection that took place on the 2nd of February 2018. Even on that basis, there was a breach of regulation 36(3)A, which requires safety checks to be carried out in intervals of not more than 12 months. So the court had before it a breach of the 12-month obligation. And then it's the first sentence of paragraph 35. The court was simply not persuaded that the fact that it wasn't undertaken every 12 months did not mean that the landlord could not comply with paragraph 6A. So the consequence is that even if you do it late, because the whole purpose of the regime under the 2015 regulations was to be remediable, you can do it late. Of course, what you've got here is you've got the impossibility of remediation where you've got 36(6)B, because what's taking place is taking place. My client cannot find the record. That's where it's at. The comments of Lady Justice King, I think, also bear focusing upon. I'm conscious my reply is 20 minutes, so I will certainly be sitting.
I don't know whether Mr. Decker is prepared to trade a bit of time on the basis that Mr. Cohen is going through the same sort of case.
I know that.
I get that's also a nod from Mr. Decker.
Very quick. Lady Justice King at paragraph 40, and the paragraph under it quickly summarises her concerns. Paragraph 40, the primary concern there is that you cannot put it right if the tenant's case was right. If you could not give it pre-occupation, at the point of section 21, you cannot put that right. And of course, exactly the same applies here. And alongside the inability to put it right is the consequence of not being able to put it right. And the concern there is expressed in the final sentence of 41. The tenant's assured tenancy becomes a fully assured tenancy with accompanying security of tenure. And it's important when one thinks of the Schedule 2 basis, there is a reason why Section 21 is described as no fault eviction. So there is a radical transformation of the security of tenure that the tenant achieves by being able to debar the landlord, not the tenant does so, but the landlord being debarred from Section 21. And that was concerned to Lady Justice King. Paragraph 41, she describes it as a serious sanction, but one that would only apply under Regulation 6(6)B, because the 2015 regulations say don't worry about the 28-day requirement, the 36(6)A. And at 42, again, there's reference to disparity of outcome does not seem to me to fit with the legislative scheme as a whole. And again, we have that disparity here. And in fact, if anything, the disparity is made more stark. Because the effect of Trecarrel is to make inroads into the obligation to give notice under 36(6)B. But those inroads having been made simply leaves the unusual factual circumstances that faces the court in both of these appeals under, I think, a glaring light. Because there, they hadn't given it when they should have given it, but they gave it late. In my appeal, for example, the check was done, the record was produced, but we simply can't evidence what took place in 2007. And at 43, her ladyship makes the point at 43.1 that all the other prescribed requirements are being remedied. 43(2), including tenancy protection legislation, has Section 21, or rather the bar to it, was collateral to the criminal sanctions that already exist in 1974. 3, there's no obligation to give the gas safety record prior to granting the tenancy, it's simply prior to occupation. 4, the words at a time when in section 21A provide that one should be able to do something to enable him to cease to be in breach of the requirement. And again, that's what we have here as an impossibility because you can't evidence something. You can't concoct the evidence, so to speak. I'm not blaming that in it.
Well, isn't that just a happenstance of this particular case? I mean, it's not a legal impossibility, is it? Because you might have had the evidence.
Well, the judge found that there was an inspection. We did have the record. We just simply don't have the records go back to 2007 and British Gas only go back to 2012.
But if the law were construed as requiring you to do something that you literally cannot do, I can see that would be an impossibility. This isn't quite an impossibility in that sense. It just happens that because it's a long time ago, no doubt, the evidence which could in theory have been there isn't there.
Yes, but if one looks at the other appeal, there is a literal impossibility because no check was undertaken at all. So it would seem strange that, in a sense, my client's position is worsened because it's an evidential impossibility rather than a literal impossibility. In fact, my client did more than the landlord in the other appeal. But as I say, it seems strange for the evidential impossibility to somehow be weighing more heavily.
But your interpretation, and that's what we're concerned with on this appeal, your interpretation doesn't depend on that factual background, because your submission, I think, would be exactly the same if there had been, for example, a deliberate breach of a requirement in 2014. Is that right?
Exactly right, my lord, and that's why the appellant in the other appeal, in effect, adopts my interpretation, because it matters not whether it was done, not evidence, or not done at all on either of the 3 interpretations that the landlords put forward. So again, at 43(4), we see the emphasis of there being some mechanism for remedying the breach, and then the mechanism which is relied on by the court in 43(5) is set out there. And 45, final 6 lines of 45. Proper interpretation of regulation 2.2 should, in my judgment, recognise that rather than the escape clause for the landlord applying only to regulation 36(6)(a, so as the escape clause was the landlord's argument that 36(6)(b just did not apply at all, resulting in a great disparity of incomes between 36(a) and 6(b, regulation 2.2 sets out to disapply the 20th compliance in relation to existing tenants in order to achieve an equal outcome in relation to an earlier failure to provide a gas safety record, whether to a new or existing tenant. And the basis of that case for providing the equal outcome was to provide that late compliance was good compliance. My lady, for the next 15 minutes, I'm going to move through my interpretations. They are self-evident in that it's simply a full way I recommend. I say that any of my 3 interpretations, and I enumerate 1, 2, and 3 simply to demarcate them rather because I think one is better than the other, but any of those 3 would mean that my appeal allows, is to be allowed, I should say. Interpretation 1 focuses on section 21A and the 2015 regulations. And before I come to interpretation 1, I will just make some short submissions on the purpose of the 2015 regulations given what we know from Harker. The first is that the primary purpose of the 2015 regulations is not safety in and of itself. It isn't safety. There is, in 36(2), an obligation on a landlord to keep all gas safety appliances safe. That is the duty. But that's not imported as a prescribed requirement. So it's wrong to see the 2015 regulations as focusing on safety in and of itself. Nor is the focus on doing the checks. If it was the checks, then it wouldn't rely on 36(6), it would rely on 36(3). So it's not about safety, it's not about checks, nor is it about the timing of checks. We know that because Lord Justice Patton in Carroll provides that even if you don't do it every 12 months, that doesn't debar you from relying on Section 21. Nor is the focus on record keeping. We know that because under the 1998 regulations, you only need to keep it for 2 years. Nor is the focus on prompt notification to the tenant. It's not prompt notification because the 2015 regulations provide that you don't need to worry about the 28 days that you need to under the 1998 regulation. So if you take a step back and see them in the round, it's not about safety, it's not about checking, it's not about timing, it's not about record keeping, it's not about keeping the tenant promptly informed.
I mean, it is in a general sense about safety.
But it's actually, in my submission, more about the tenant's knowledge of danger. But again, that only goes so far in circumstances where, because it's the provision of records.
Quite. I mean, if you're told the day before you get a Section 21 notice that actually everything is terrible, that doesn't help you very much.
So it is in a general sense because it fits within the health and safety limb, so to speak, of the prescribed requirements. But actually, if you drill down to the 2015 regulations, it's about giving the tenant knowledge, but not even giving the tenant prompt knowledge, because you don't need to do it within 28 days. All of that actually begs the question for what is the purpose of 2015 regulations. And in my submission, the purpose of it is to ensure that at the point of the Section 21 notice, the landlord has got to have the records and to have given the records.
Well,
It
another
is-
way is you've got to have safe premises in guest terms in order to be able to give the Section 21 notice. So
Exactly, but
it's
only,
a restriction on landlords.
indeed, but only at the date of the 21 notice. That's what's critical, because the consequence of Carroll is both the pre-occupancy notice can be as late as you want. You don't need to do your 12 months check. So actually the question is simply, is the property safe at the date of the Section 21 notice?
Which might seem the point at which it doesn't really matter anymore.
Well, in many ways,
But it may be seen as the landlord shouldn't have the privilege, if you like, of being able to serve the notice under Section 21 if they haven't made sure the premises are safe.
And my lady, that feeds into what we see in the other provisions of the Deregulation Act. You should not have the privilege of terminating a tenancy at a time when you have not complied with certain obligations. So if you think about the preventing of retaliatory eviction, they complain about disrepair, so you try and kick them out. Well, you can't do that until you've repaired it. You think about tenancy deposits, you haven't properly protected it. You can't serve Section 21 until, so to speak, your ducks are in order.
That makes a lot of sense with deposits. It's
It-
only, you only worry about the deposit at the point at which the tenancy is coming to an end. So you need to have the deposit sorted at the point at which you're bringing the tenancy to an end.
Indeed, my lord, but the point's still made good if you think about preventing of retaliatory eviction. Suited for disrepair, you serve Section 21 notices. Well, you can't until the repair's made good. So what it means is that at the date of the notice, you, the landlord, have got to abide by whichever obligation is then extant. It's not previous obligations. The fact that it was previously in disrepair is neither here nor there. And equally with a deposit, you can make it good by putting it in a scheme. So really what it is at the date of the notice, have you complied with any extant obligation? And it's for that reason that I recommend interpretation 1 to you. Interpretation 1 uses, if one goes to page 109, as its springboard, so to speak, 109. Regulation 2(1)(b), there's a reference to a gas safety certificate. That regulation 2(2), there is an express limitation to give a copy of the relevant record Now those words are in the singular, and my own friend Mr. Morris is of course will make reference to the Interpretation Act, but I say when one thinks of the purpose of this, one has the necessary contrary intention. Because those singulars, in my submission, are chosen deliberately. The reference to the relevant record means the relevant record evidencing that the most recent check has been done. And further support, but I don't put a great deal of weight on it, can be found in the explanatory notes, which again just references this singular and makes the point that the no fault eviction procedure for ASTs is not available to land at a time when either the EPC requirement has not been satisfied or the gas safety record requirement has not been satisfied. So with the purpose of the 2015 regulations in mind, in my submission I commend interpretation 1 to you because it fulfills all of the purposes. It's consistent with the provisions prohibiting retaliatory eviction in the Deregulation Act, which is in the bundle. It's consistent with the provisions so far as deposits are concerned, and most importantly, it's consistent with all of the concerns which face the court in Carroll. Now, importantly, it gives purpose to both limbs of Regulation 36. Intra-Carroll, what the landlord was arguing was actually Regulation 2.2, because it refers only to the 28-day requirement, means that 36.6b is in its entirety irrelevant. I don't think it is irrelevant in its entirety. And the reason for that is because landlords can serve Section 21 notices after 4 months. So prior to the Deregulation Act 2015, the common practice was for landlords to serve Section 21 notices at the date of the tenancy itself. We see support for that behind tab 21, this is page 499. 499, authorities bundle. This is extract Woodfall, landlord and tenant dealing with ASTs, and if one looks at footnote 13, it states that section 21(4)d was inserted to the Housing Act 1988, which I'm going to come to, by the Deregulation Act, and it renders ineffective the former common practice of landlords of giving a section 21 notice of commencement of the tenant. So what the Deregulation Act did was say, well, you can't give your section 21 notice at the beginning of the tenancy because you used to have them hand in hand, so to speak. And in its place, it provided that you couldn't do so for the first 4 months. That's in section 21. I'll just get the page reference. So far as it says, 29. It's page 29. So tab 3, page 29, introduce 4D. So you can give a section 21 notice. On 29. The notice under subsection 1 or 4 may not be given in relation to an AST or dwelling house in England in the case of a tenancy which is not replacing the tenancy within the period of 4 months, beginning on the day on which the tenancy began. So you can't give a section 21 notice for the first 4 months, but given the prevalence of short-term ASTs, which is noted by Lord Justice Carroll, what one is seeing thereafter the Deregulation Act is that section 21 notices are given after 4 months and 1 day. Gives 2 months notice, provides that it can't terminate until the end of the fixed term and you have your section 21 notice. Now, of course, if that notice is given during the first year of the AST, it's going to be regulation 36.6b, which is the record giving obligation. But of course, after you've gone beyond the 12 months, it's regulation 36.6a, which will then bite and provide for the 12 months. Albeit the consequence of Tracaro is that you don't need to do it 12 months. So the reason why in my submission, interpretation 1 fits with the legislative purpose and fits with Tracaro is because just as under regulation 36.6a, you just need to give a record, the most recent 12-month record, even if you haven't done it for many, many years before. One gets the most recent record, which can either be under 36.6b or a, depending on the point at which the section 21 notice is served. So there is purpose in 36.6b, more importantly, it actually is consistent with the statutory purpose, which is making it safe at the date of the Section 21 notice, rather than penalising it for failures to make it safe at any point prior to that. An argument is going to be made by my own friend Mr. Morris that it's not open to this court in light of Tricaro. I've made my submissions of that in my written submissions. Tricaro was dealing with different facts and different arguments. Tricaro was given late, and in Tricaro the two arguments that were made is it's okay to give it late, and Regulation 6B is ignored in its entirety. I say it's not ignored in its entirety. It is relevant, and in fact will be relevant for the vast majority of ASTs, because they are short-term ASTs and Section 21 notices are commonly given within that first 12 months. That's what I'm going to say on interpretation 1, so to speak. Moving to interpretation 2 as I close up in 5 minutes. Focusing on interpretation 2 looks at the 1998 regulations, and I'm going to, if I may, go through the same procedure of identifying the purpose of Regulation 36.6. Regulation 36.6 is not about, 36.6b I should say, it's not about giving the tenant information before the tenancy is entered into. It's only after the tenancy is entered into that it's engaged. It's not about giving a tenant a cause of action or a statutory remedy. It is about giving the tenant information of a certain quality in 4 respects. First, the content of the information has got to be exact. Regulation 36.3c is prescriptive as to what is required. Names, addresses, dates, certifiers, which appliance has checked, any defaults. The next is that the information has got to be, in inverted commas, recent. It's got to be within 12 months of the commencement of the lease. We know that because it aligns with the check that has to have taken place within 12 months of the lease under 36.3b. The next is that the information has got to ensure that the tenant is aware of issues with gas appliances, which is self-evident. And the final one is that it's got to be given pre-occupation. Now, if one thinks of those principles, it'll be clear in my submission to this court that the consequence of the judgment does not align with those principles. Because the judgment penalises my client for not being able to evidence something done in 2007. Whereas what Regulation 36.6b about is the quality of information which has got to be given at a certain point. It's got to be within 12 months, and it's got to be given pre-occupancy. The fact that it's got to be given pre-occupancy shows that late compliance, so to speak, and I'm focusing on regulation, 1998 regulations, but it's like 2015, late compliance is of no value to the tenant whatsoever. It's got to be given pre-occupancy, and it's got to be within 12 months. So it's got a shelf life, and it needs to have certain content. What interpretation looks to do is link the tenancy which identifies the occupant as a new tenant with the word occupation. Now, on the facts of my case, for example, it would simply mean that before the November 2019 tenancy, was there a gas safety record given within the 12 months prior to that? We know that there was on the 24th of October, and there's no dispute about that. And the words that I invite this court to interpolate into 36.6b is pursuant to the new lease which renders that person a new tenant after the word occupiers, which again is in my skeleton argument, so I won't take that much further.
So it says in a conventional case, if you had a lease granted pursuant to which the tenant did not immediately take occupation, this would work fine.
Indeed, but in my submission it also works fine if the tenant is already in occupation pursuant to a tenancy, because
Yes.
the obligation is to give notice before they occupy pursuant to the tenancy that renders them a new tenant. So in circumstances where you've got renewal tenancies, 36.6b, notwithstanding 36.6a may mandate the same thing. 36.6b will mean before you occupy pursuant to the new tenancy, you've got to have given notice within the 12 months. Now, by way of an example, what you could have is you could have someone going into occupation pursuant to a 20-year AST. There's no obligation to give notice there because it's not a lease as defined in the 1998 regulations. If they are thereafter granted a lease within the 1998 regulations, then rather, which is the case for the tenant's construction, the judge's construction, having to give information which relates back to before the 20-year tenancy, you simply give information which relates to the 12 months before the tenancy is granted, the tenancy as it is defined in the 1998 regulations. And in that regard, linguistically, I derive support for that from first, the fact that the definition of tenant is indelibly tied to the lease that gives them the right to be there for the time being. That's what tenant means. It doesn't mean that you were a tenant, it means that you are a tenant under the existing lease. So new tenant therefore means you are coming to that existing lease for the first time. The next is that if you look at 36.6b, the saving clause removes tenants whose rights to occupy those premises, and it's the fact that it's the right to occupy those premises that leads occupation onto the tenancy, the right to occupy. And the final one is that 36.6b mirrors 36.3b. That's the purpose of it. 36.3b is about checking within 12 months before the commencement of the lease. And what the judge's construction does is divorce 36.6b, giving of the record, from the check 36.3b. And we can see that there should be alignment between the two because 36.6a aligns with 36.3a. In my skeleton argument, I make various subsidiarity arguments. I just commend them to you. I don't intend to go much further. In the judgment, the judge rejects interpretation 2 because he felt that it left no relevance to 36.6a. My answer to that is simply there's no reason why one record can't fulfill both roles. Given the purpose of this is tenant information, it doesn't really matter pursuant to which basis one does it. The final one, my last 2 minutes, is interpretation 3. I'm very conscious that Mr. Morris has got much to say. Interpretation 3 provides for the last 2 notices, and in that regard, it borrows from the decision of Her Honour Judge Clark and Castle and Sidney. If I can just take you to tab 24. This is page 518 to 30. In that case, one gets this from paragraph 2 at 519. The tenancy itself, this is paragraph 1, tenancy dated 7th of May 2021. There was an inspection on the 14th of January 2021, this is paragraphs 1 and 2, so there was an inspection 14th of January 2021. The gas safety record was given before occupation, but the gas safety record was incomplete because of the final sentence of paragraph 2. The box for details of customer landlord is, however, blank. So here you've got check, certificate given pre-occupation, but the certificate itself was faulty because not every single bit had been filled in. There were further inspections pursuant to 36.3a, which took place during the term of the tenancy. This is paragraph 4. And there was no issue with the gas safety records that were given pursuant to the 12 monthly inspections. That's paragraph 4. The tenant defended the claim simply on the basis that there had been no valid pre-occupancy gas safety record because that's improperly been filled in. That's paragraph 6. The discussion is at page 541. It starts at 541. In paragraph 62, the judge agreed that the pre-occupancy gas safety record was invalid because it did not give the address. That's paragraph 62. Follows that I agree with Deputy Secretary to the failure of the first gas safety record to specify the address was a breach of regulation 36, so it cannot be aligned as evidence of compliance with regulation 36 as prescribed requirement. 64, the question is put, does that mean that section 21 is not available in circumstances where there was a valid second and third gas safety record given at the 12-month intervals? and the judge concluded that the second and third gas safety records were sufficient for the purposes of the 2015 regulations. And I'm going to summarise as I move through paragraph 65 very briefly why it was that she came to that conclusion. Paragraph 65(1) was that you, as the landlord, are only required to retain records for 2 years, which is why she, in a sense, related back from the section 21 notice. So you need 2 notices because you've got to keep them for 2 years. That's 65(1). 65(3) is why should you have to evidence compliance, which is separate sets of statute says you don't need to keep. 65IV was, well, once you've done the 2 later checks, the original one is simply historic. That's the 4 lines at the bottom of 65IV. 65V is that it makes no obvious policy for practical sense. 65VI is all about lack of evidence. You could be penalising people who can't evidence it, which is the case in my mind. And then 67, first 6 lines of 67 is the judgment. So far as interpretation 3 is concerned, I've got nothing more to add other than simply advancing that analysis to you. I'm very conscious I've eaten into everyone else's time. I will beg leave for a 2-minute final response if necessary, but it won't be more than 2 minutes. And I certainly accept I'm not entitled to anything.
Mr. Morris.
Start by saying how grateful I am to Mr. Cohen for setting out in detail the statutory scheme, which hopefully will save the rest of us some time. What I propose to do is to start off with some general submissions in response to what Mr. Cohen has said, and also attempt to address my Lady Justice Falk's variation on interpretation 2. I'll then come on to Trecarrell because, as I've said in writing, my submission, that is a complete answer to all of the 3 interpretations that are run. I'll then dive into the linguistic analysis, expand on what I've said in writing, and finally, perhaps if there's time, address something to your Lordship's knowledge about the statutory presumptions on which Mr. Cohen relies. I will try as much as possible just to rest on my written case, because I'm mindful that Mr. Decker will need to rise at some point, but I would hope that what Mr. Cohen has comprehensively done nonetheless will make his task an easier one. So if I can then start then, just by putting the section 21A sanction, and I call it that deliberately, into its wider context, because much has been made in the landlord submissions about the injustice of the consequences of the judge's interpretation in this appeal for landlords. But the gravity of those consequences in my submission must be weighed up against the rights which landlords retain under Section 7 of the Housing Act, even if they cannot rely on Section 21. And as I've submitted in one of my many skeletons I think the court has before the court, it is inapt to describe Section 21 as a no-fault regime, because in fact under Section 7 a landlord can recover possession under a range of grounds, none of which require any fault on the part of the tenant. Section 21 simply entitles a landlord to recover possession without actually giving any reason for wanting possession. So my submission perhaps is that it might more aptly be described as the no reason regime, so as not to overlap with the grounds available under Section 7. And Mr. Cohen showed you where they were in the bundle. These are the grounds in Schedule 2 to the Housing Act. So Authorities Bundle tab 3, starting on page 46. And this is common ground, I think, between us. So I'm just going to summarise, if I may, the no-fault mandatory grounds for possession that remain available to a landlord. So the first is ground 1A, and that is that at some time before the tenancy was granted, at least one of the landlords occupied the dwelling house as their only or principal home, provided that they first gave notice in writing that they might rely on this ground, or the court thinks it just and equitable to dispense with notice. So just pausing there for a second, you do not even need to demonstrate to make out this ground that you want possession because you want to live there yourself. It is sufficient that it was once your home and you now want it back. The second is ground 1B, so this is the I want to live there ground. At least one of the landlords needs the premises as their only or principal home, or that of their spouse or civil partner, provided that they've given notice in writing in advance, or the court thinks it just inequitable to dispense with that. And then skipping over ground 2, which is really for mortgagees, if we come on to ground 3 on page 47, this is if the premises was a holiday home in the year before the tenancy and notice is given in writing before the tenancy of that. And again, you don't even need to say, I want it back as a holiday home. It's sufficient that it was, in the 12 months before the tenancy, occupied as a holiday home. Then ground 6 is the reconstruction ground. I need it back because I want to demolish the premises and I can't do that with you in situ. Ground 7 over on page 50 is the death of the tenant ground. You're allowed to recover possession from those who remain in the dwelling house. And the final no fault ground is ground 9 on page 55. Though this is a discretionary ground, so this isn't a case where if the ground's made out, the court shall make a notice, the court has to think it just and equitable to do so. And this is simply that suitable alternative accommodation is available for the tenant or will be available for him when the order for possession takes effect. And the meaning of suitable alternative possession is explained under part 3, which I won't take your lordships and ladyships through, but it's on page 60 of the bundle. And the reason that is important in weighing up the Section 21A sanction is because very clearly a landlord can still recover possession on a whole range of no-fault grounds if they have a reason for doing so. And even where Section 21 is not available, a landlord's economic interests are also fully protected under Section 7, well, in fact, under the scheme of the Act, because they are entitled to recover possession on various fault-based grounds. Mr. Cohen showed you the rent arrears grounds. There's also a breach of covenant ground, damage to the premises, damage to the furniture, albeit that, except the ground 8, the serious rent arrears, they're all discretionary grounds. Nonetheless, a landlord retains its right to possession if the court thinks it just and equitable to grant it. And the final point to keep in mind, of course, is that even if a landlord can't establish one of those grounds, so they're stuck with their tenant because they can't rely on a Section 21 notice, it is ensured that they will nonetheless be able to receive the market rent because they can serve a notice under Section 13 saying, I want to increase the rent. And if there's a dispute about that, they can apply to the first tier tribunal for a determination of the open market rent. So all of that in my submission is important to keep in mind when weighing up the proportionality of the consequences of the judge's decision below. And that leads into a second general submission that I'd like to make. It's submitted by the landlords in both appeals that the construction, which is Honour Judge Hellman preferred, renders somehow a breach of Regulation Regulation 21B of the 2015 regulations in respect of Regulation 36.6B irremediable. Now, with respect, that is not quite a correct characterisation of what the judge here decided. We know from this court's decision in Carroll that a breach of Regulation 36.6b, i.e. a failure to give the pre-occupation gas safety record before occupation, can be remedied for the purposes of the 2015 regulations by late provision, i.e. by late compliance. And His Honour Judge Hellman's construction leaves fully available that route to remediation. Doesn't make it irremediable. The complaint here is in fact from landlords who did not comply with Regulation 36.6b in the first place, or at least in Mr. Cohen's client's case, could not give any evidence that they had, and are therefore not able to remediate their earlier breach by belatedly providing what should have been provided in these cases a long time ago. That does not make the breach irremediable, it just means that these particular landlords, in fact, are not able to remedy their earlier breaches. And to that extent, my respectful submission is that Mr. Decker's focus in his skeleton argument on the so-called failure to retain the gas record is to focus on the wrong thing. And likewise, Mr. Cohen's focus on the inability to prove service of a gas safety record in 2007 also focuses on the wrong thing. Just pausing there for a second, Mr. Cohen in his submissions on a number of occasions suggested that his clients are in this position because they cannot prove what was done. I just urge a degree of caution there because in fact the Deputy District Judge made no findings that anything was done. It wasn't their case that it was done. Their case was limited to the fact that they had a contract with British Gas and British Gas would have sent it to the property. But there was no basis evidentially for supposing that in fact something was done, they just couldn't prove it. But that's perhaps a factual dispute that needn't trouble the court too much on the present circumstance of this appeal. But anyway, the point of the prescribed requirements in my submission is to impose a sanction on landlords who have not discharged their duty under Regulation 36(6) in the first place, and who cannot belatedly comply. The correct characterisation in my submission is that the sanction becomes substantive, or as Mr. Decker puts it in his skeleton argument, penal, not because of a failure to retain the GSR or an inability to evidence something, but because a landlord is in breach of an original obligation to do something before the tenant went into occupation and is unable to make good that breach through belated compliance. And that leads on to my third general point, response to Mr. Cohen, given the emphasis on consequences. I just want to draw to the court's attention some other principles from Benyon, which Mr. Cohen skipped over earlier, as one might expect. So if we can go back into the authorities bundle behind tab 20, we've put all of chapter 13 in, and Mr. Cohen took you to some of it. This is the chapter where the editors distill the various principles from the cases about the so-called presumption that an absurd result is not intended.
So what page is this?
I'm sorry, it's I'm on page 450. And Mr. Cohen showed you on 451 that this is but a presumption. And the strength of the presumption, of course, depends on the extent to which the consequence can be said to be absurd in the manner, in the sense of the meaning given to it by the authorities. So in other words, it is important in my submission to keep this sanction in context, this consequence in context when considering the extent to which this presumption applies. But I would like to refer in particular to page 452. Just above the example at the bottom there, it says, however, a mere assertion that a particular construction would produce an absurd result will not necessarily carry much weight, particularly where the legislation in question creates what appears to be a coherent statutory scheme, and there is no obvious way of construing the legislation so as to correct the alleged absurdity. And the theme of my submissions in writing and orally to the Lordships and your Ladyship will be that the language of this legislative scheme makes clear that this in fact was what Parliament intended. And next, if I can skip over please to 458. So this is the presumption against absurdity means that the courts will generally avoid adopting a construction that produces an unworkable or impracticable result. And in particular, if I can show you page 459, the editors set out some examples of unworkable or impractical results. And then in the middle of the page, just underneath the quotation from Lord Justice McComb's judgment, the editors say, however, these examples may be contrasted with cases where the legislation creates a coherent legislative scheme reflecting policy choices that could reasonably have been made, and the allegation is that the legislation produces unworkable or impractical results. And again, theme of my submissions will be that these two statutory schemes, when fitted together, reflect policy choices that Parliament as a rational legislature can be taken to have intended. And in any event, in my submission, it's not really right to suggest that those consequences are unworkable or impracticable, save in certain factual cases like these. And finally, on anomalies, over, if I may, on page 465, this is section 13.5, avoiding an anomalous or illogical result. If I can just draw to your Lordship's and your Ladyship's attention the passages which are sidelined on page 468. The principles that the editors gather and summarise there, that sometimes a particular construction will be adopted even though it produces an anomalous or illogical result. And they set out some of the relevant categories. Of course, the court may always decide that the legislature intended the anomaly. That concludes the matter, for the court's aim is always to ascertain the legislative intent. And then in the middle of the page, complex statutory schemes may result in anomalies, especially when first introduced. Courts may accept anomalies in such cases, particularly where they are not readily capable of being cured by interpretative means. And at the bottom, the introduction of a new statutory scheme may also give rise to anomalies as regards what is and is not dealt with under the new law. That is inevitable. It is the nature of the commencement provisions and transitional provisions that a line is drawn somewhere. There's then a quotation from Lord Justice Buckley, which I've set out in my skeleton. But if I can just again focus on 469, underneath grammatical meaning not outweighed by anomalies, just to stress the court's function is of course to ascertain the legislative intention, given the weight to be attached to the grammatical meaning. Where the meaning of a provision is otherwise clear, the existence of anomalies may not be sufficient to displace that meaning. The position, however, is different, where the anomalies amount to an absurdity that the legislature cannot have intended. And then there is the quotation just underneath that from Stock and Frank Jones Tipton Limited, where Lord Simon pointed out that Parliament is nowadays in continuous session, so that an unlooked for and unsupportable injustice or anomaly can be readily rectified by legislation. This is far preferable to judicial contortion of the law to meet apparently hard cases, with the result that ordinary citizens and their advisers hardly know where they stand. And then his lordship set out beneath that a test, or some things which must be satisfied in order to depart from the grammatical meaning to correct an anomaly. And having taken the court through all of that, there is something I'd like to draw attention to in the 2015 regulations themselves, back into tab 8 of the authorities bundle. And it's a provision that we've not looked at yet. It's Regulation 5, which is on page 112. And what we see here is that the draftsman has in fact baked into the legislations a sort of release valve, because what is provided for here is that the Secretary of State must from time to time carry out a review of Regulations 2 and 3, set out the conclusions of the review in a report, publish the report, and that report must in particular set out the objectives intended to be achieved by the regulatory system, assess the extent to which those objectives are achieved, and assess whether those objectives remain appropriate, and if so, the extent to which they could be achieved with a system that imposes less regulation. We must at this point remind ourselves that these regulatory provisions were introduced by the Deregulation Act of 2015, which is possibly the most misleadingly named act in English legislative history. And what we're then told is that the first report under this regulation must be published before the end of the period of 5 years, beginning on the day of 1st of October 2015, and reports under this regulation are afterwards to be published at intervals of not exceeding 5 years. Now, we don't have these reports in the bundle. I had a little look yesterday to see if I could find them. I'm afraid I couldn't. I did find, however, a parliamentary question asked by a Conservative MP to this government asking if they were going to do a review, and the answer was, don't be ridiculous, we're abolishing Section 21 anyway, so there's no point. So that is the answer in respect of the second review, but whether or not there was a first review, I'm afraid I don't know. But my submission anyway is that the contents of that review, whatever the Secretary of State thought about Parliament's intention in the 2015 regulations, wouldn't shed any light on the actual meaning of those regulations long after the event. The reason I'm drawing attention to this is because, of course, it is relevant to these arguments about absurdity and consequence. Parliament obviously thought that it should keep this under review, and if it thought that it had over-regulated or produced absurd outcomes, then one would have thought that it would have been moved to amend these regulations then. Obviously, it has not done so. I've got 3 minutes before lunch. Perhaps if I can just try and address my Lady Justice Falk's variation on interpretation 2, or is that something perhaps best raised after lunch?
Rather depends on how comprehensively you expect to be able to cover the point in the 3 or 4 minutes.
I think I'll struggle to do it justice in 3 to 4 minutes, but I can make a start.
I wonder whether the convenient thing is to rise now, but to extend the court day by starting again at 1 to 2.
Yes.
Court rises able.